What we're here to talk about tonight is property tax appeals. I'm sure everybody here has seen the fact that taxes have gone up way too much in the last few years. So hopefully this class will give you the knowledge to be able to fight property taxes, save yourself a bunch of money. We have a special guest here tonight, and I'm going to read from a little bit from his bio. His name is Jason Long. He's an attorney. Jason does property tax, real estate, land use disputes, and successfully represented clients in Michigan's trial courts and the Michigan Tax Tribunal, and the Michigan Court of Appeals, and the Michigan Supreme Court. Jason routinely helps clients reduce their property tax obligations. He recently represented a Tier 1 auto supplier in a Michigan Tax Tribunal, resulting in an approximate $500,000 or $600,000 difference in company tax. That's a lot. Jason is a frequent author, presenter on tax and real estate topics. He has published articles and books, chapters for the Michigan State Law Review, the University of Detroit Mercy Law Review, et cetera, a lot of stuff. And kind of an interesting thing, he's a member of the board of directors for the University of Detroit Mercy Law Alumni Association, and he actually did a clerkship for a Supreme Court justice. So give me a warm welcome for Jason Long. Let me set you up with your, okay. If that's the right one. How many people brought some of their tax forms with them tonight? Nobody?
Jay, my computer is sufficiently old. It does not have an HDMI.
Okay. Let's see if we have. Brian, Hey, Brian, can you help with this? Or Tommy? Did I say Brian?
What do you need?
He needs a different
HDMI.
He doesn't have an HDMI. Can we borrow?
Flash drive.
Where is he at? Raj, can we borrow your notebook? Here, you help him, please. We're having some technical difficulties.
It's hot. Nuclear hot. Yeah.
Live. Thank you, everyone, for having me tonight. Thanks, Jay, for the introduction. And I like the way Jay put it. I am a sometimes real estate investor myself, and I've screwed up plenty of things, plenty of times. And I always like to think of it as you learn a lot more from your mistakes than from your successes. So what I want to do tonight is talk about a couple different things, and I'm going to try and move quickly through some parts and maybe talk a little more in detail on other parts. But the first sort of half, I don't know if it'll really be half, but the first part of my talk talks about sort of the substance of Michigan property tax law, where it comes from, what the tax laws say, and then the second half talks about sort of the process and procedure of challenging your property tax assessment. So without further delay, let's see if I know how to work this. I don't. Can we hit the key? All right. There we go. Okay, so Michigan, as you may know, Michigan has a constitution of its own, and the Michigan Constitution, well, you know, our fundamental law, the basis of all of our laws, actually provides for a property tax. And it doesn't really give a lot of detail about it, but what it does say is that the legislature is going to adopt a property tax, a general ad valorem tax, so a general tax based on value for real property and tangible personal property. And it's based on value. The Constitution then says that the legislature is going to decide how to determine what value is. So in the 1890s, the legislature adopted what's today called the General Property Tax Act, which says that all property, real and personal, in Michigan that's not exempt is going to be subject to tax. And I keep pressing that. There we go. Did I skip one? I did not. I'm sorry. So, real and personal property. Real property is kind of what you would expect. It's land, it's buildings, it's fixtures, which is a term that is abused. It is appurtenances, which means like easements and things like that. So any property that you have that includes an easement, that easement is part of the property. It's taken into account in what is taxed. And just to illustrate that, I had a case once years ago where I was representing the city of Taylor. And back then, it was a Marshall Field's department store at Southland Mall. It was on a pad site. So what Marshall Field owned was just essentially the square where its store was located and none of its parking. And Marshall Field says, we got the store, it's got no parking. What's the store worth without parking? Not a whole lot. Well, they had easements for the parking all around the mall that they could use. So once the tax tribunal in that instance understood that, you know, your property, which is the pad site, has appurtenances, easements that allow you to use as parking, it's a regular store the same as any other. Their argument that it wasn't worth that much withered away. In any instance, or in any event, excuse me, real property, like I said, what you would expect. Personal property is kind of like everything else. Everything that's not real property, it's hard to say this is what personal property is. It's if you read the definition, it's sort of repetitive because it's hard to describe. But the one area where there was some sort of lack of clarity was a building on leased land, and whether that building was real property or personal property. A few years ago, the legislature decided we're just going to treat that as all real property, so you don't have to make that distinction anymore. More pertinent is value, true cash value. That's what the standard is called under the General Property Tax Act that is the basis for property tax. So true cash value means the usual selling price of a property at a private sale, not at an auction sale or at a forced sale. And as the courts have said, true cash value is synonymous with market value. And it's a sort of a generic definition of market value. In other areas of the law and other kinds of legislation, market value is defined differently. For example, if you've ever run into a condemnation problem where a governmental agency is acquiring a part of the property to widen a road or put in a new water line or something like that, market value in those instances is defined as the highest price. Here it's the usual price. What's the difference? It's sort of like a thumb on the scale in the condemnation context. Here it's supposed to be sort of a straight down the middle definition of market value. And while the Constitution says the legislature is going to decide about true cash value, the legislature hasn't done a whole lot to give direction on that. So what you end up with instead is the courts, for example, in a case from the 1980s called Antisdale, the Supreme Court observing that the legislature didn't really tell us how we're going to decide what true cash value is, so the courts have to figure it out. And, you know, in any tax tribunal case or tax appeal, you're sort of using appraisal principles. It's based on appraisal methodology, and it's the standard appraisal techniques that you're probably all pretty familiar with: sales comparison, income capitalization, sometimes cost approach. An important thing to know for residential property is that in determining true cash value, there are limits on what cities and townships can take into account when you change that property until it sells. So there's a section in the definition of true cash value, and this is the section, and it might be a little hard to read. And for anyone who's interested in this, I have handouts, hard copies of this. But there's a section in there that says, until a property sells, changes you make in the property, like that are routine maintenance, like painting, replacing windows, replacing awnings, putting new roofs on, wiring, repairing, insulating, new ceilings, walls, floors, and everything that's on this list cannot be taken into account. And this is something that cities and townships very often are very happy to gloss over. So if you have a residential property, and it only applies to residential property, and you're doing this kind of work, the city or township can't increase your assessment because you've done it. It is off limits until the property sells. They just have to sit there and look at it. And when you sell it, then your buyer will have a property that takes this into account. But while you have it, as long as it is residential property and it maintains in your ownership, these kinds of changes should not be taken into account and should not be a basis for an increase in your assessment. There was a recent decision where this was very much isolated to residential property. It involved a lawyer's office building up in Bay City, and they put a new roof on their office building. And they said, hey, that's not, and so the city took it into account as an addition. As you may know, you can have an increase in your property tax assessment, and we'll talk about it in a little more detail, for an addition. And these guys said, this isn't an addition, it's a new roof. We haven't added anything, we've just done some maintenance. And the courts ended up saying, well, the roof that's there now wasn't there before, so it's an addition, so whatever increment of value it's worth can be taken into account. And that was for their office building that would not apply to a residential property. A couple other notes about determining true cash value, and this would apply or may be of interest to folks here who have multifamily properties, is that if you're doing an income capitalization approach, or if you're doing any kind of valuation based on the rents you're generating, it has to be what's called present economic income, which the courts have interpreted to mean the rent that would be available under current market conditions. So if you have a property, for example, where you have a bunch of old leases on it, and it's not cash flowing great because the leases are old, and if you could clean out all the tenants and do it all over again, you'd get more rent. The latter, the rent you could get under current market conditions, is the rent that you should be taking into account and that the assessor can take into account in determining a value. Old leases don't necessarily provide a basis for getting your taxes reduced if they're a drag on your value. Likewise, though, if you have leases that were entered into under market conditions when people were paying more in rent than they are now, the same thing is true. Those high leases aren't necessarily a basis for your assessment to be more than what it would be if you used present economic income as this is defined. There is an exception for this for co-ops that dates back years. It's fading away and it's not that applicable, but it's on the right there if you want to take a look at that. So let's talk about true cash value is what the standard is. There's a couple of other values that the General Property Tax Act talks about that are also critically important for you to know. The first one is assessed value. And most straightforward, assessed value is supposed to be half of true cash value, so half of market value. And this is the standard, and this is what property was taxed based on for many years in Michigan, was assessed value, half of its market value in any given year. That changed in 1994 when the voters in March of that year adopted an amendment to the Michigan Constitution that introduced the concept of taxable value into Michigan law. So taxable value is an additional value that's assigned to every property. And when it was first introduced in 1995, it was the same as your assessed value. And when a property stays in the same ownership, the assessed value can go up or down depending on what the market value is. The taxable value changes only with an inflation rate that is based on the CPI. So this, while your market value and therefore your assessed value could be increasing in a good market, your taxable value should be going up only by the inflation rate, whatever it happens to be, which can't be more than 5%. If it's more than 5%, it caps out at 5%. But this can lead to some kind of weird things. As I'm sure all of you know, the consumer price index is not the real estate market. The things that drive the consumer price index are food prices and energy prices especially. And sometimes those can be moving in the opposite direction of the real estate market, but nevertheless, you will end up with taxable values going up when the real estate market maybe isn't. And that was something that happened a fair amount back in the Great Recession. There was at least a couple of years where property values were decreasing significantly, but inflation was still, kind of staying on the same course, and you had assessed values and market values coming down. But for people who had owned their properties for many years and had a difference between their assessed and taxable values, even though their market values were coming down, their taxes went up because of inflation, because that was based on the CPI, which was doing something different than the real estate market. And if you have that scenario, if you've owned your property for a while and your taxable value is low compared to where your market value and assessed value are, it's a disincentive to sell. It sort of locks up our market for residential properties because people, if they sell their property, they're going to buy a new one and they're going to start this process over again. It's kind of like being locked in with a low mortgage rate. You can be locked in with a low taxable value that you don't want to give up, and you're going to need to sell for more in order to walk away from that.
Just to note real quick on that, in this last year, the change was only 1.031%, as opposed to, most people think that we're, high percentage. It's only been 5% once since twice. Sorry, but right this year it's only 1.031% increase.
Right, it was 3.1% this year. The 2 years preceding it was 5% each year because it would have been more if it could have been, but it hit that ceiling at 5%. If you look back at the entire course of this since Michigan's had it, beginning in 1995, the average overall has been about 2.25% or 2.4%. So this year we're a little above average, but we're well below where we've been the past couple of years, where if you look from 2022 until today, your property taxes have increased by more than 10% just in that couple of year window. Like I said, taxable value generally only can increase with the inflationary rate, but there are some exceptions to that. One is for additions. Things that can be brought on as additions would include omitted real property, which means things that are there that weren't taken into account. And this can be, it really is a wide spectrum of things that assessors try to sneak in on this. I've had clients call with homes where an assessor comes out and says, hey, you have a deck that we weren't taking into account, so we're going to add a few $1,000s to your taxable value because your deck is worth something and you were getting away with it before. Other additions are new construction, which is a little more intuitive. If you build something new, yeah, that's going to get taken into account. Replacement construction, which should not result in a big change in your taxable value if you do it within a certain amount of time and if it's replacing something that was destroyed in a fire or tornado or something like that. And an increase in value attributable to environmental cleanup. The flip side of that is that a taxable value can be reduced for losses, for things that you lose in a fire or a tornado, things that are you find that they are contaminated, and you learn that, well, this is worth squat now because it's got all this contamination on it. Things that cannot change your taxable value that are a little bit counterintuitive are platting, splits, or combinations, because if you have a really big property and you split it into some smaller ones, supply and demand would tell you there are more buyers for those smaller pieces than there were for the big one. But all this assessor can do in that instance is basically divide it across the new pieces and not increase the value because you've got smaller pieces for which there maybe is a larger market. Or a zoning change. As you guys all probably know, a zoning change can significantly and profoundly affect the value of a property because it affects what you can do with it. Notwithstanding that, it's not a basis for an assessor to increase your taxable value. The big thing about taxable value is that it can change and it resets to equal half of your market value on an ownership change, a transfer of ownership as it's defined in the General Property Tax Act. The foundation of that is in the Constitution. It's in the provision that was adopted as 1994. This is where it specifies you can only increase by the inflation rate until you have that transfer of ownership. And transfers of ownership is defined in the legislation. And it includes a lot of things that you would expect: a transfer by deed, transfer by ownership. If you enter into a land contract, it's a transfer of ownership at the time you make the sale to the land contract purchaser, not when the payoff takes place. Certain leases can result in transfers of ownership. Or if you have a property that's in an LLC or a corporation and you transfer more than 50% of the membership shares or shares of the corporation to a new owner who's then effectively in control of it, that too can be a transfer of ownership. Certain things are not transfers of ownership, transfers between spouses. Spouses can transfer their properties back and forth to each other all day long. It never changes anything. A conveyance subject to a life estate. If any of you are familiar with the concept of a ladybird deed, the idea is that you can sign a ladybird deed and the transfer won't take place until you die. Transfers of certain residential property to members of your family, sons, daughters, granddaughters, grandchildren, if it stays a residential property, which means it cannot be used as a rental property. Transfers coming out of foreclosures or forfeitures. So if you have a land contract forfeiture, for example, that would not be a transfer of ownership. And a few others, security interests, so mortgages, things like that, can go back and forth, and that's not going to be a transfer of ownership. A big one and an important one is conveyances between legal entities under common control. And this is one that people like to talk about and always have questions about. So this would be, let's say you have a holding company and then you have LLCs for each of your properties. If you're the only members of those LLCs, your holding company and your individual property LLCs, you can move those around without being concerned that it's going to be a transfer of ownership and cause an uncapping. Where there is a real gray area and real inconsistent treatment by cities and townships is what happens when you own your property personally and you put it into an LLC. Or you own it in your single member LLC and then you take it out. Because very often you have to do that. If you have some property that's in an LLC and you want to refinance it, you may have to take it out of your LLC, put it in your name personally, do the refi, and then put it back into your LLC. The legislation does not address that. It just says legal entities that are commonly controlled. Is a person a legal entity? The courts haven't been consistent about that. There are, however, guidelines that the State Tax Commission, which is an agency of the state of Michigan that supervises assessors, the guidelines that the State Tax Commission has issued say if you have a person who owns a property individually or a married couple that owns a property, and they put their property, either the individual or the married couple, into an LLC where it's a single member LLC or an LLC where the married couple are the members, that should not be an uncapping. And you can take it out the same way and put it back in. As long as you're not adding or changing members, the guidelines say that should be okay. But the guidelines aren't binding. There are directions to assessors, they're not law. Some assessors in some communities look at them and say, yeah, I'm not gonna do that. So if you have that scenario, what I would suggest to you is make a call, take a drive down to your local assessing office and try and chat someone up. And what they tell you, you know, it's not binding, you're not gonna be able to hold them to it, but it will give you more direction than you'll have if you don't do it. And it should give you the information whether this is a community that is going to follow the guidelines and allow me to do, you know, in and out of a single member LLC, or if this is a place that wants to pick a fight about it. And I wish I had something more definitive to tell you, because that's something that investors deal with all the time, but it's a gray area. For the most part, most communities follow the guidelines and allow you to do it. But there are a few, I can think of a few up north, for example, that like to buck the system and don't want to do it that way. A few other exceptions are, you know, if the land has a conservation easement on it, sometimes people will get a property, put a conservation easement on it because it's a good way to park some money for income tax purposes. You can transfer that property over and over, and the taxable value is not going to increase. A couple others are if you have joint tenants with a setup where if you own it with someone jointly, you die, the property goes to that other person. That's a complicated scenario that the law has a lot of little nuances on it, but that's another area where transfers of ownership are generally accepted. Related to transfers are property transfer affidavits. And this is something, if you make it a sale or do a transaction, you have to file something, the buyer has to file something with the city or township saying, I now own this property. And I always suggest to people, do it even if you think you don't have to. Because if you get into a dispute later, the consequences can be pretty ugly. If there's something that happens, there's something that's a transfer, no property transfer affidavit is filed, and the city or township could learn of it 20 years later. And 20 years later, they can go back to the date that it happened and charge all the tax that would have been there, all the late fees that would have been there, all the interest that would have been there. So property transfer affidavits, my approach is file early, file often, make sure you get it in, because once you do that, once you submit it, there's no way for them to go back in time on you. Briefly, you know, there are exemptions from property tax for government agencies, nonprofit entities, some low-income housing, but it's really narrow what's available and exemptions for that. The principal residence exemption would not apply to an investment property, but it might apply to the home where you live. It exempts you from the school tax, and in most communities it winds up being about a 1/3 tax break compared to what you'd otherwise have to pay. It's something that the legislature likes to tinker around with, because I think legislators get calls about it from people all the time, so there are bills coming in all the time. So it's something that if you have some sort of dispute, you have to really keep up on it. It's available to a property's owner, which can mean really only a person who actually owns it under a deed or a land contract purchaser. It can be a partial owner, but it can't be a tenant, and it can't be an LLC or anything like that. It has to be a natural person. And it applies to the house where you live and any adjacent land, but it has to be the house where you live. It's described, the standard is the true, fixed, and permanent home to which, whenever absent, he or she intends to return, he or she being the owner. And it's highly fact-specific. If you ever have a dispute about this, be prepared with all kinds of documentation to show that you live where you live, that you have your driver's license, your voter's registration, your utility bills, all kinds of bills are generally used to demonstrate actual residence. To get it, you have to file by June 1st to get it on your summer tax. If you blow that deadline, you can file and get it on your winter tax in November. It may or may not do you any good depending on the community where you live and when they bill their school taxes. If it gets denied, if, like, for example, a city or township, or in some instances, the State Department of Treasury, learns that you're not living in the home where you've been receiving a principal residence exemption, or you didn't own it, they can retroactively deny it for the year you're in and the 3 years before, and they will bill you for all the taxes that would have applied, penalties and interest. A scenario where it comes up where you didn't own it is where someone had a deed in a drawer that their parent signed waiting for the parent to die, and that happens, and then they go and record the deed. Well, the deed may have been recorded in 2025, but it was signed in 2018. So if you try to have a principal residence exemption on that property in 2025, well, you're going to lose it for the time before that, excuse me, because your parent who lived there then didn't own it. Briefly, personal property. I wanted to include this because it may be something that could apply if you have a small office where you do your property management, investing, things like that. If you have some equipment there, you're probably getting some kind of personal property tax assessment and personal property tax bill. The first $180,000 of, or well, not the first, the $180,000 of equipment, furniture, computers, and so forth is exempt. If you don't have more than $180,000, you submit a form, shown there in a way you can't see, but you could Google it and find it immediately. You submit a form to your local assessing office that says, I don't have more than $180,000 of equipment at my office, and then you're exempt. It's a little unfair that if you have $180,001, then $180,001 is subject to tax. But if you have only $180,000, then that $180,000 will be exempt. Assessment challenges. So that's sort of the end of the basics of what Michigan property tax law is. So we're going to talk about assessment challenges now. And this is something that you've probably all been receiving recently, and if you haven't, you'll be getting it soon. And it says in all caps, bold letters up at the top, this is not a tax bill. And that's true, it's not. But in many ways, it's more important than a tax bill because it has the values on it that are going to be the basis for your tax bill for the coming year. And let's go back to that for a sec. So this has a few different pieces of information on it. And if you look, this one is from Grand Rapids, and it's for a property on Plymouth Avenue. And this was an apartment complex that a client in my office owned. But there's a few things that are included here. And you'll see that at the top, in the top left box, you've got the assessor's office. In the top right, you've got the parcel number and the property address. The boxes below that are identify the owner and whether it receives a principal residence exemption. And you can see in this instance it says 0% there because this was an apartment complex. The next row below that is a very important row for you to take a look at if you're interested in doing a property tax appeal. Because it says, according to MCL 211.34C, which is a provision in the General Property Tax Act, this property is classified as, in this one it says 201 commercial improved. And there are a few different classes and codes in Michigan, and 201 is commercial, anything with 200s is commercial. But if you look there and you see something in the 400s, and usually it'll say residential, but class 400s are residential. Those are properties that require a special step to do an appeal. Anything that's class residential or agricultural, and agriculturals are in the 700s, and again, it usually will say agricultural, but it must be protested at the March Board of Review. And the assessment notice at the bottom, you probably can't read that, I can't even read it on my screen here, But it has information about the March Board of Review, when it meets, and what you have to do to protest there. But if you have a property that's residential or agricultural, you have to go to the March Board of Review. It is required. If you do not do it, you will not be able to go any further. It's a box you have to check. Most of the time, it's a waste of time, but you have to go. You have to do it. And there are little tricks involved with it sometimes. Like some communities, if you send an agent out to do it, some communities require you to have that agent to have an original wet signature, not a scan of an email from you. If you're there on a property that you own in an LLC, some communities may require like some kind of resolution from the LLC authorizing you to be there on its behalf. There are little tricks and obstacles that communities set up to try to whittle down the number of people who are bringing valid property tax assessment appeals to them. So it's worth a phone call, a look at your local ordinances to find out, or just a thorough read of the notice of assessment, which sometimes have a backside that includes all these requirements, to make sure that if there's something that you have to do to go to the March Board of Review, that you know what it is and you're able to do it and you're not there scrambling to get it done. Another one is that some places require an appointment. And if you don't make an appointment and you try to do a walk-in, they say, we're not taking walk-ins, and then you haven't appealed to the March Board of Review and you're foreclosed from trying to go further to the tax tribunal. And this applies to both classes, real and ag property. If you make it through the March Board of Review, you check that box. For property class, commercial, industrial, or developmental, if you want to file in the tax tribunal, you have to do it by the end of May. And that, property that's commercial, industrial, developmental is going to include mostly what it sounds like. But things that are commercial sometimes can be a little foggy with things that are residential. If you have a 4-unit residential building, that's probably going to be residential, but not necessarily. But if you have a 5 or 6 unit, it's very likely to be commercial. So that's something you want to look closely at if you have those kinds of properties and you're thinking about whether you want to appeal, both to know whether you need to go to the March Board of Review and to make sure you're looking at the right timeline. If for things that are residential, ag, a few things like timber cutover, which is almost non-existent, the deadline is July 31st, but it's July 31st after you go to the March Board of Review. Again, you have to go to the March Board of Review or you're going to be foreclosed from doing anything more. A couple examples of petitions. If you go on the tax tribunal website, they have forms that you can fill out and submit to the tribunal to initiate your appeal. This is a form for what's called the entire tribunal division. And the tax tribunal has what it calls entire tribunal and small claims. And the differences are that entire tribunal is more like litigation in the Oakland County Circuit Court, let's say. It's like a real lawsuit with deadlines and status conferences and court appearances and the like. Small claims is a lot different than that. So this is a sample petition. You don't have to use the tribunal's forms, but sometimes it's helpful because sometimes the people who are receiving these at the tribunal are used to getting them, and if they get something that's not this, it freaks them out a little bit. So it's better to give them what they know how to handle. This is the form of petition used in small claims. I don't know how well you can see that from out there, but it's a little simpler. Again, these are available on the tribunal website if you want to look at them, but the small claims form is more like fill in your name and address, what is the property, tell us what your problem is, and your problem can be as simple as it's not worth what you guys think. Who can bring it? So if you fill out one of those petitions or you want to bring an appeal, it has to be brought by a, quote, party in interest. So if you have a property that belongs to an LLC, it has to be the LLC that appeals. It can't be you as the member of the LLC. It can't be you as the person who ultimately pays the bill. It can't be your holding company if you have a holding company and then a few single asset LLCs. It has to be the actual entity that owns the property. It could be a tenant in the property, or it could be a person who has some other kind of interest in the property, but it can't be the person who is financially responsible unless that same person actually has some kind of ownership interest in the property. And that came out of a case called Spartan Stores versus City of Grand Rapids, and that was essentially Spartan Stores Inc. is a holding company, and they have grocery stores all around the state, but each of those grocery stores is its own LLC. It was, an LLC in the City of Grand Rapids in this instance, and Grand Rapids looked at this and said, Spartan Stores Inc., you don't own this property. And they were right. The court said, they're right, Spartan Stores doesn't own it. And their appeal was dismissed. You got to bring the appeal in the name of whoever the actual owner is. Sir?
So if you have a property in an LLC and you want to appeal it, if you go to court for a tenant, you normally have to have an attorney represent you. Are you allowed to represent yourself at an appeal court for your own LLC?
You are. In the tax tribunal, you can appear on behalf of your LLC. It's unlike, if you have a tenant that you want to boot and your property belongs to an LLC, you have to have an attorney go represent you. You do not have to do that in the tax tribunal. A little bit about tax tribunal procedures. This is an order that is issued in entire tribunal cases, in the more formalistic cases. You'll get, if you have an appeal pending in the entire tribunal, a couple months after you file it, you'll get one of these. It sets a series of deadlines. The most important one is a deadline for you to file an appraisal. And, most cases don't actually involve getting an appraisal. Most cases you file, you get this thing, it sets a deadline. The deadline is going to be probably 6 months, 7 months away. And so once you have this, you're sort of on the clock. And that's when some conversations start between the assessor or the assessor's attorney and the property owner about what's this thing really worth, how do we figure it out, what can we agree on to put this to bed and not have to spend the money to get an appraisal to submit to the tribunal and let the tribunal decide. In an entire tribunal case, if any of you guys have ever been involved in litigation, it's very much like litigation, like I said. You can have discovery where the city or township is sending you requests for documents and written interrogatories, which are written questions you have to answer under oath. They can ask for depositions of people. So if you are saying this thing isn't cash flowing, I don't have any tenants, they're going to demand, rent rolls, lease forms, balance statements, things like that. And if you don't produce them, eventually you'll run into a problem and very likely have your appeal dismissed. So when you get into an entire tribunal dispute, you have to be prepared to give up that information. And really, if you're in the entire tribunal, you should want to show it to the city or township to be able to say, look, this property isn't producing, it's not worth what you guys think, and here's the evidence. So that's something to bear in mind, because in any community where the assessor or his or her attorneys are worth their salt, they're going to ask for that stuff. Valuation disclosure is essentially your appraisal. It doesn't have to be an appraisal. That's an interesting point. You would probably want it to be an appraisal if you had a case pending, because it's going to be more credible, it's going to be more believable. But I've certainly had people use other things. I've had clients who were investors. I can think of an example, a client who bought and sold self-storage facilities all over the country, who thought, you know what, I know more what these things are worth than some bozo appraiser who's going to come in and charge me a fee. And he got up and testified about it, and the tribunal actually really believed his testimony, and he got a good result out of it. But most of the time it's going to be an appraisal. Most people don't have the depth of knowledge that this individual had to be able to provide that kind of information. Again, in the entire tribunal, you'll get motion practice. A lot of what you might get is motions to compel, to demand a property owner provide that information I was describing. In the tax tribunal, the evidentiary standards are a little looser than they are in courts. You can rely on things that reasonable people rely on. The biggest place where that comes in is hearsay. I'm sure you've all heard, if nothing else, maybe on TV, objections about hearsay. In the tax tribunal, hearsay is actually okay. Let's talk about small claims appeals. These are going to apply to, smaller properties, residential properties, properties where there's a little less in dispute. They go much faster. So I was describing before, you file your petition and then a couple months in the entire tribunal, and a couple months after, you get your scheduling order that says 6 or 7 months from now, exchange appraisals. If you file a small claims appeal, it's very likely that 2 months after you file it, you're going to get something saying your hearing date is in 60 days. So the whole thing could be over within a matter of about 4 months. It's much less formal. Most of them are held by telephone or in some instances by Zoom, depending on the parties or the judge or hearing referee's preference. There's no discovery, so they can't compel you to give up information in these. And sometimes you don't get a tax tribunal judge, you'll get a hearing referee who's an attorney, or in some instances a former assessor, or maybe a part-time assessor who's looking to pick up some other work, that hears the evidence and decides what the value would be. Real briefly, because it's tax related, I wanted to just touch on tax foreclosure. And it may be for this group of investors, it may be pertinent to if you are buying a property out of tax foreclosure, if you're watching a property that you know is headed that way, what the timeline would be. And it's generally a 3-year timeline. So this year, for example, the court is in Oakland County, the circuit court is going to foreclose real soon on properties that didn't have their 2022 taxes paid. And if for that property, the 2022 taxes are unpaid, in March of the following year, notices start going out. In November of the following year, there's a publication and a case gets filed. And in February this year, so I'm not sure, it may have happened already or it may be upcoming, but there's a hearing where people can show up and say, hey, you shouldn't be foreclosing on my property because of something. And the something that someone can bring up to a circuit court judge to say you shouldn't be foreclosing on my property is especially narrow. There are maybe 2 or 3 things that are a valid basis to pull a property that has unpaid taxes out of foreclosure. Interestingly, one of them is a pending tax appeal, because what you're essentially saying to the court is you can't foreclose on my property for unpaid tax because the amount of tax that's due is in dispute. But for everything else, the court enters a judgment on March 1st, and the judgment says, all right, that's it, you got a month. And at the end of March, if the taxes aren't paid, the property is irrevocably gone from its former owner. And what happens after that involves a few things. Initially, not a whole lot. After the judgment's entered, title is irrevocably transferred to usually the county. And what happens then is there's sort of a series of steps involving different governmental agencies. The first thing the county does is it sort of does an inventory of says, what do we have? And then the state and its departments all sort of have dibs on saying, we want to pull that property out from you, Oakland County, and the state or the Department of Transportation or the Department of Natural Resources will take ownership of it. If the state passes, then the city or township where it's located has next dibs on it, and they can say, we want to pull that property out of the foreclosure pool and own it as a city or township. And what can happen in these steps, and I've seen this happen with cities and townships, is if you have a property that gets tax foreclosed, and at the time when the city or township sort of have dibs on it, you can go to the city or township and say, hey, I own that property next door to that, or I own the property behind it, and I'd like to buy that property, but I don't really want to participate in the tax foreclosure auction. And you can approach the city or township and say, if you pull it out of the foreclosure pool, I'll give you a good price for it. And what's a good price? Well, it depends, and that's to be worked out. But you can sort of secure properties that way by going and trying to work with your local officials instead of just hanging around and waiting for the foreclosure auction where who knows what's going to happen. But if that doesn't happen, you make it to the foreclosure auction in Oakland County. I think it's usually in July. Maybe it's in August. They've been doing it over at what used to be called the UWM Soccer Arenas over on South Boulevard in Pontiac. And, you know, it's all for the highest bidder, and if they don't sell there, then they end up online. That is the end of my spiel. Jay, are we doing questions now, or do you want to wait a bit?
Well, let's start off. Does anybody have anything specific questions on something that he brought up? And then we'll go over some questions that I had pre-done as well. Come on up to the mic and ask your questions, or yell them out loud.
Yeah, just a yell out. I just wonder that how the property tax handle that for the second homes, like not the.
So a second home is going to be taxed at the same rate that would apply to, you know, commercial industrial properties. The second home is not and I want to give you the standard, but it's not the one true place where you're going to return whenever you're gone. It's a second home. It's a place where you go sometimes. So the tax rate that applies to it is sort of the full rate. You get all the normal taxes and the school tax. It's the same rate that applies to commercial, industrial, et cetera. I described that your PRE property gets about a 1/3 tax break. That would not apply to a second home.
I have another question. Just to be clarified that for the multifamily, that when the transaction happens, when the sale happens, it's been handled the same as the independent house, right? I mean, if the true what is the tax value?
Yeah. For any property of any stripe, when there's a transaction, when there's something that qualifies as a transfer of ownership, in the following year, the taxable value will be able to match the assessed value. Most often it involves, you know, an increase in the taxable value, so it's that the buyer is going to have a higher tax obligation than the seller had. Yes, ma'am. The red shirt. Burgundy.
Okay. You said that basic maintenance like paint, carpeting, floor doesn't make it improved. What about a minor kitchen or bathroom remodel, like changing the cupboards, new countertops?
It should be the same. Let's go back to that list. And again, for anyone who wants it, I have hard copies of this, and I can tell you where to find it online. But let's get back to that, because there's a lot there, and I don't know them all offhand. So you're seeing here replacing plumbing. That's pretty close to that. Go ahead, Jay.
I was going to say, my understanding, and tell me if this is right, is that unless you're changing the square footage of the home, an addition, a garage, something like that, maybe even adding square footage in the basement by adding egress windows or something, unless you're changing the size of the home, then anything that's inside there, any repairs you do is not a change.
I think that's generally correct. And it's, you know, it doesn't have new cabinets, new appliances here. Appliances are not real property in any event. But I think the gist of this is that should not be taken into account, and I would make that argument to my assessor if I were doing that. Sir, I see your hand, but there's a gentleman in the back who I went past last time. Sir, with the gray shirt on there? Yes, sir.
Yeah, what's the process if you notice that your taxes have been increased beyond the 5% in a given year? Say you notice that it happened a year or two ago or 5 years ago, that sort of thing.
So if it happened well, I guess there's a couple parts to the answer to this. In general, if it happened even as recently as last year, it's too late. That train left the station. You got to do it in the same year, generally speaking, or you can't do it at all. The only instance where you can go back in time is if you've had a transaction where the city or township looked at it and said, that's a transfer of ownership, we're going to uncap you. And you can demonstrate that it, in fact, was not something that qualifies as a transfer of ownership, like a conveyance between two related LLCs. That you can unwind for the current year and a couple of years prior, but if it's just that, they blew it, they didn't apply the multiplier correctly, there's nothing you can do about it from years past. You can only correct it in the current year. It's her up front.
So when you go to that March of board meeting, so I have an LLC. Is it the registered agent that has to attend?
It doesn't have to be the registered agent, but if you're going on behalf of your LLC, you can call the city or township and say, hey, do you require anything? It might be good just to have a resolution from your LLC, a piece of paper that says, 456 Main Street LLC authorizes you to appear on its behalf at the March Board of Review. If you're the only member, you then sign as member, and be armed with that when you go there, so that if a question comes up about it, you can say, oh, I have a resolution from the LLC authorizing me to be here. It doesn't have to be the registered agent. An LLC could resolve to have anyone go and speak on its behalf as long as it resolves to do that. Yes, sir.
So if I sell my house to you on a land contract, that would uncap it, and we would have a new tax rate. So 8 years down the road, I forfeit you and I take it back, that would uncap it again, correct?
No. If you forfeit me, that does not uncap it again.
Okay,
But-
foreclosures or anything different?
I'm sorry?
If I foreclose or do anything, I take it back from you.
You take it back from me, it does not uncap it again, but you pick up where I left off. You don't go back to the taxable value that you had before you sold it to me. Over here.
If I have a fire in one of my units, and that, say I have 4 units and I have a fire in one, and because of which my livable area reduces, is that a case to reduce my taxes?
It would, if you had a fire, that's a loss. So yeah, if it reduces your livable area, that's a loss. And it should be the case that you can, I wouldn't say appeal, I was going to say you might be able to appeal if you need to, but you can also restore it without whatever you do being a restoration. So it might be, it's sort of like, while it's a loss, you take a step back, and then when you restore it, you step back to where you were at the beginning, plus the inflationary multiplier.
So if I, on the flip side, if I buy a building that's got 2 units worth, and I restore it, does that mean my taxes would increase?
Probably, because, but what you want to do is make clear that, hey, I bought this and it has 2 units burned that are unusable, so the price you put on it in the year after I bought it ought to reflect that.
So that's actually a question that is going to work well with the Detroit side of it, that Detroit is very good about lowering your tax burden for things that need repair. We'll talk about that in a little bit. It still works in the burbs, but only if you can truly prove it, et cetera, that you had a fire or something. You can't just walk in and say, somebody stole my furnace, can you lower my tax? Generally they won't, but Detroit does. Who's next?
Gentleman with the gray jacket here.
I know you mentioned it's kind of a gray area to transfer ownership from an individual or a couple to a single member LLC. But what if it's like an LLC with 2 or more members? How would that work?
It should, if you have, let's say you have 3 people who own a property, and you put it into an LLC where they're each equal membership interest members, the guidelines say that should not be an uncapped. Cities, a few places like to not follow the guidelines, but that you should be safe with that.
And the same applies to like a married couple?
Yes. Sir with the blue shirt here.
I had a question about foreclosure. You said that it should not be an uncapped event if there is a foreclosure. But what happens after the sheriff's sale? That would be an uncapped event, would it not?
The sheriff's sale to the buyer
Right.
is an uncapping event, because that's not the foreclosure, that's post-foreclosure.
Okay, but the whole process is, we go to foreclosure, and the bank, a hard money lender, so I put a bid in as my minimum.
Your credit bid.
Right, and the foreclosure sheriff's sale doesn't happen,
Right,
because
right, so you,
nobody bid.
right,
There's
but,
no bid.
yeah, so when it comes back to you on your credit bid, there should be no uncapping.
Okay, thank you.
Yes, ma'am?
Okay, so when in this process do you go to small claims court? slide about small claims.
Yeah, so you would go in this process, you'd go to the small claims, and they call it the small claims division of the tax tribunal. You go there, so you get your assessment. If it's something that's headed for small claims, you probably are going to have to go to the March Board of Review and check that box, even if, you probably won't get anything, but you got to go. And then you can file anytime after your March Board of Review through July 31st, which is the deadline. And anyone who's interested in it, I would say wait until April 1st to file in the tax tribunal, because the tax tribunal really likes to wait until all the March boards of review are done, until it starts taking new appeals for the year. And when do March boards of review happen? Anytime in March. There are communities that have them right up until March 30th.
Sorry.
So to answer your question, man, is anytime after your March Board of Review, up through the end of July.
Okay.
Yes, ma'am.
If I'm not buying from if like transaction happen not in the auctions, but through the transactions, I got the property is really below the market values. So, but when I got the appraisal that they still use the market values, so the best way is to appeal is to get appraisal.
Yeah, I would say that if you have an auction sale or sale.
It's not through the auction sales, no. It's just the general transactions, but somehow that the condition of the property is not that good, so the sales price is a little bit lower than the market values.
Yeah, you're going to want to, if you have an appraisal that demonstrates that, that's going to be your best evidence to bring forward.
Okay.
Gentleman, the red shirt. That's you. Yeah, that's you.
If I convert a covered carport into a garage, will that add on tax?
Most likely it would. That's most likely going to be viewed as an addition. You got like studs and drywall and things like that. So yeah, I expected that would.
And if I do a separate garage, like a detached garage, that will also add?
Same, yes. Sir.
At what point will that be put on his taxes? Say he's got a permit open, he's doing the project, post-inspection, I assume?
It's always the following year. So it's the following year. So if you're putting up a new garage in 2025, it's going to show up on your taxes in 2026. The tax day in Michigan, so the day properties are evaluated to determine what they're worth for tax purposes, is December 31st of the preceding year. So for this year, you look at a property, what was its status on New Year's Eve? And if the garage was there and done at that time, it can be taken into account. If you're just starting it yesterday, it'll be picked up on next year's tax.
That also adds to the point of if you're going to get an appraisal or if you're going to use your own comps or something for an appraisal, you should do it as of December 31st of the previous year before that.
That's a great point, Jay. And often people will bring an appraisal that was done in conjunction with the purchase to their assessor to make their case. And one of the things the assessors like to say right out of the box is like, well, this is as of the wrong date. If you bought a property in January in a declining market, you're all to the good. But most often, recently especially, what you see is if you bought something in January, by the end of the year, hopefully you've gained at least a few percentage points of value because of an increase in market. Sir.
Back to the transfers to prevent uncapping. Per the property transfer affidavit, we know entities are common control. It also states, or among members of an affiliated group. What is defined as an affiliated group?
An affiliated group generally refers to a series of, it almost always has to be corporations, so not LLCs. And it's more than 2 or 3 entities. This doesn't come up very much. There's very little authority addressing what it means. But that's generally the way the tax tribunal has approached it, is that it's different than common control, because common control lists a number of legal entities that come under that umbrella. And it's, partnerships, LLCs, trusts. But members of an affiliated group has been applied in a way that means only corporations, only when there's at least a few. Yes, ma'am.
We have a rental property that's owned by me, my husband, and our son, and we want to buy him out. So just the two of us will own it instead of three. Is that uncapped?
Do you own it in your, just personally, the three of you?
Yeah, personally, three of us.
It should not. It should not, because unless you have established it in a different way, the default rule is going to be that you own it is what's called under Michigan law tenants in common. And if you buy out two tenants in common, buy out one other, or arguably in your case, because it's you and your husband, you're sort of like one person under the law, and married couple buys out that other person, you should be safe with that.
Just do a quick claim deed.
Yeah, I would just have him do a quick claim deed. It says from him to you, and he just says, whatever I had, it's yours now, and you should be safe with that. There was someone this way. Yes, sir.
Does change of use or rezoning cause an uncapping?
Should not. There's a specific provision that says a change in zoning is not an uncapped.
So changing, let's say, from a duplex to a triplex shouldn't cause an uncapping?
Well, are you changing the zoning, or are you changing it by splitting off a piece of it with a wall and a new entrance? Because that's different.
Changing the structure of the building, essentially.
Yeah, changing the structure of the building isn't going to cause an uncapping, but it might give you an addition.
Even if the total square footage doesn't change, that can still cause an uncapping?
It can. If you're putting up, new walls, it really depends on the nature of the work, but you might end up with an addition from that.
And in some municipalities, they keep the basement, but they tear down the house and they avoid a tax increase. Is that based on a state law, or is it based on some municipality, how they handle it, or?
The only instances I can think of that is when something has gone down in a fire. So I can't speak to that specifically. I'm sorry.
So a couple of kind of basic questions that hopefully everybody will learn something from as well. What do you think is the most common way to determine if your property is overassessed and eligible for appeal? What do you think is the number one that is brought to you, I suppose?
It really varies by the kind of property. If it's a single-family home, it's sales in your neighborhood that demonstrate that, on some kind of unit basis, per square foot, per bedroom, per room, that your value is too high. If it's a multifamily, it's the same thing. It's that things are selling on a per unit in that instance. Per unit basis, sales are, maybe $70,000 a unit, and you're assessed as if you're worth $100,000 a unit. You might want to think about appealing that. That's really the most easily demonstrated ways to suggest that a property is a good candidate for an appeal. If you have something that is a multifamily or commercial, you can look at your rents, but it's really easy to get into arguments over what's the right cap rate or what's the right income multiplier, because as you know, a small difference in those numbers makes a big difference in the value where you come out, and it's a lot harder to present that as a basis to go forward with an appeal.
Can I interpret that the sales price is a very good indicator to judge that whether it's overvalues the appraisals?
Yeah, that's, when you're evaluating, should I take this farther, the sale prices, if you have, good sale prices of properties that you understand what they are and what their prices were, that's the best basis to decide, whether to move forward.
Some people think that I bought the property as an opposite of that. Some people think, oh, well, I paid $20,000 for this property, and I'm being assessed as if it's worth $100,000 because every other property in the neighborhood is worth 100,000. You think, well, I paid 20, so I should be charged at 20. Problem is it doesn't necessarily go by your purchase price. It goes by supposedly the average of properties in the area that are like-minded. The usual selling price. So just because you got a good deal doesn't mean that you're going to get it lower. And conversely, the same thing. I've seen people say, well, you know, I paid $150,000 for this, and everybody else in the neighborhood is $100,000. I should be taxed at the same rate they are. The idiot defense doesn't work. If you paid too much and you spent that much money on the property, they're going to say that's proof, even if there are lower comps in the area, that it's close enough. They could still charge you for that higher amount.
I've been successful with the idiot defense sometimes, because it depends, but you got to have enough sales to show that, yes, I overpaid for this, or you have some reason that you overpaid for it. It's like I needed to be here because of X, or I needed to close within, 10 days, and I had to pay the freight.
I've heard a horror story, and I'll ask you the question. Have you ever seen anybody go to a full tax tribunal to fight their taxes, went all the way up the process saying, I think I'm paying too much, I think I'm paying too much, go all the way to the tax tribunal and find out that they underassessed, and the tax tribunal says, you know what, I'm charging you more.
Yes. One of the first cases I ever tried involved a multifamily property down in Taylor. And for reasons I won't bore you with, the case involved like 20 tax years. So it went back to the late 1980s at that time. And when we finally got a decision, and I wasn't practicing then, but I took over this case. When we finally got a decision, the tax tribunal said, not only are you not paying too much, you haven't been paying enough. So for those years that applied before Proposal A, before taxable value was a thing, those guys had to pay more tax. So yeah, that can happen, absolutely.
Conversely,
For your case, for the neighborhood, it can be the house maybe sells every about hundreds, but each house condition is different. If you got it like 50,000 house, maybe the condition is in a pretty bad situations. But what is this tax law that basically for the house improvement should not be adding your tax?
They look at all the houses being equal and in fair shape, equal shape. So if your house you paid a lot less for because it has a lot of repairs that are necessary, you can go to, and that's more Detroit than most places, but I'm sure everybody can. You can go to them and argue the fact that, listen, these are all the things that was wrong with this. That's why I bought it less, and I would like a tax break specifically based on condition. And that does work.
Did that just work in Detroit? What about South?
I've seen that. That works everywhere. But I wouldn't say I'm here to get a tax break. You say I'm here to be taxed on the property that I own. Because the property that I own, had a crumbling basement, had whatever it had. On December 31st, this is what it was like. This is what you get to assess. You don't get to assess property that didn't exist. You assess what I had. And if it had a bunch of problems, you need to make sure that you can demonstrate what they are, document them, and present them in a way that's understandable so that they can be taken into account.
So I've gone to the property tax appeal process in probably about 8 or 9 cities. East Point, Warren, Roseville, etc., Detroit, of course. And up until I started hitting Detroit really hard, all those other cities didn't care if I told them that the property was in bad shape. Now maybe I didn't fight it the right way, but I always just walked in and said, hey, my property's not worth this much because look how much I paid for it, and gave them comps saying that I think that this property is worth less. They never took that. But the minute I started bringing in invoices and pictures of the property, specifically in Detroit, that's how I learned about Detroit actually, then they started changing things. I'll tell you the short story about Detroit actually. I'll kind of jump onto Detroit a little bit. The first couple times we went to Detroit, tried to fight the property taxes, I brought in CMAs, BPOs, different prices for what I thought properties were worth, and every single time the city would just deny me straight out, and I would lose. And every year I kept going back when I bought new properties and tried to argue it, and I would lose every single time. Then I came one year, it was 2015 or 16 I think it was, and that year they allowed everybody to come into the room, or the 5 or 7 people at the same time. They'd walk into the room, and you'd sit in chairs on the side while they're doing the board review. Willie Donwell, nice guy, that the board member or board chief, whatever you want to call it, he would start asking people questions, and we got to actually see what everybody else was doing. The first couple guys got up and said, "Oh, well, here's showing that I believe that this property is overassessed. Here's the comps in the area." Denied. Second person came up, same thing, denied. And then this little old lady got up there, and she says, y'all say, I pay way too much for this property tax. You say it's worth this much. This guy broke in, he stole my furnace, stole my hot water tank, broke all my windows, took out part of the electric in the house, my kitchen's gone, so on and so forth. And you guys are over-assessing me for this. You think it's worth $100,000, I think it's worth $10,000. And so Mr. Donwell says, okay, well, how much do you think it's going to cost to fix the house? Oh, $30,000, easy. Do you have any quotes for that? Actually, I got invoices right here. Okay, no problem. Okay, we're going to assess your property at $20,000, $10,000 taxable value. Just like that. And I walked in, and I've got 5 or 7 houses that I'm fighting, and I've got CMAs for each one of them in my hand. I got all these paper, with that. And I walk up and sit down, and I'm like, oh, crap. It didn't work the last time. And so he asked me, what's your basis for appeal? Oh, well, the condition of these properties is bad. I started following what that lady said. The condition of the property is bad. It's got this wrong with it, this wrong with it. Okay, do you have any pictures? Well, honestly, I didn't bring pictures, but I can send them to you, no problem. He's like, okay, well, what do you think the repairs are? So I'm shuffling through CMAs, and I'm like, oh yeah, invoice for the so-and-so is $12,000 for that. And I don't have invoices, but I'm making it up as I go along. And I got between 40 and 70% reduction in taxes for every single one of those properties doing it that way. Conversely, City of East Point, I mentioned this to you actually on the phone, we were talking about it. I bought a property from Habitat for Humanity that had been given the property from the City of East Point for free. They condemned the property and they thought that it was not worth fixing, so they gave it to a charity based on the fact that they thought they were going to fix it up. Habitat said, no, we really don't want to do it. I did 9 properties for them, fixed them up, my dime, etc. And I wanted this property, so I bought it for them for a very low amount because I was helping them with some other stuff. But the city had said this property is condemned, no taxable value essentially. So when I went to fight taxes, the year after, I actually screwed up and did not do it the first year. I missed it by a day. I went to fight it and said, hey, this is all the things that were wrong with it. The city believes that this property is worth nothing. I have the city manager sitting right next to me saying, hey, Jay's a good guy, Habitat's a good thing. It's worth nothing. You should assess it at a very low amount. We think it's worth $110,000. Case dismissed. That was the board of review. Ended up having to take it to the state tax tribunal to argue it with a lawyer, actually, to make that happen. But that just shows you the difference between cities.
What did it happen?
I'm sorry?
Well, after the appeal to the state, what happened?
$30,000 of taxable value, as opposed to their $150,000, $60,000 essentially.
Do you go by that? Do you go by the SE value?
So I'll let you explain that. When you uncap a property, the taxable value and the SEV equal out. And then after that, every year, the assessed value or the taxable value will go up that maximum of 3 to 5%, whatever it is that year. But the SEV can go up higher because that's what they believe. The true cash value can go up higher because they think it's worth more. But that doesn't mean anything. It's the taxable value. Am I saying that right?
Yeah, well, generally, SEV and assessed value are the same. The taxable value is specifically the one that only moves from the inflation rate. So, SEV can go up or down depending on the market. Taxable value can only increase by the inflation. If your value dips below, the inflation rate, then your taxable value should go down. It just doesn't usually happen.
So if I buy a property March 1st of this year, that's an investor property that's got broken windows and everything, I go to the Board of Appeals for next year because it'll be uncapped, and even though it's uncapped, its value is not justified, is what it is.
Yes. So for Detroit, for this year, the Detroit is slightly different with the way that they do their board reviews, et cetera. They have an extra step. They call it an actual, I don't want to screw it up here. Assessor's review first, which you have to go through that process first. I think you have until February 22nd to apply for the assessor's review, and then you have until March, whatever the date is for the March board review. If you purchased the property last year, you're going to do that for this year. If you purchased it this year, you're going to do it for next year. So the number one thing I always say, especially in Detroit or properties that have damage, take 1 million pictures. Get your invoices, bring them with you. You can actually send an email to the board of review beforehand, or ask for their email address. Really down below, actually get his personal email address. And you can send it right to them and say, these are the pictures, these are the invoices. When I come in to talk for the board of review or bring them from the drive, we'll do that as well.
And to follow up on Jay's point, if you're going to the board review, try to make it as easy for them as you can. You know, there's like 3 or 4 people, and they have dozens and dozens, maybe hundreds of properties to review. Make it as simple for them to understand your property as you can. I try to bring like a letter explaining, here's what all the properties are, and then tab A is going to be my invoices, tab B is going to be photos, tab C might be comparable sales. You know, make it as easy for them to agree with you as you possibly can.
Just want to clarify the timeline here. So if I buy the properties like in January, and I can start to do all the fixings, I accumulate all the invoice, even for next year, like December 31st, maybe at that time the property is already being repaired to a good shape.
Well, if you buy it in January and you begin repairing it in December, the repairs are going to be done.
That's right.
So it's going to be evaluated with the repairs complete.
Okay.
So, you know, it's not going to be in bad shape anymore. It's going to be in good shape at the end of the year. And that's the shape it will be evaluated to determine its value for the following.
So if I interpret right, that for the purpose of the property tax, better not fix it, wait until the January.
That's true, but you know, it's a tail wagging the dog situation. It's like, do you want to save, you know, maybe a couple $1,000s in tax and carry this crappy property that you might otherwise fix up and have a tenant paying you some rent instead?
So I have an unusual one. I got one that was economically distressed. The tenant was $18,000 behind in rent. So the landlord said, please. And so I got it on the market. So so now the house is basically, I bought it for this, but it's actually worth this. Is that anything I can?
No, think back to that present economic rent. What's the rent you could get in the market, not with a, you know, crap tenant who doesn't pay.
You're supposed to get.
Yeah, what are you supposed to get? That's a problem, but it's not a problem that really is going to get you very far in demonstrating a reduced value for tax
Well,
purposes.
the appeals boards, they don't go, I mean, for single family homes, they don't look at your rent. They really don't care.
They really don't care about
They're
it.
look- so that's
To
very
ask,
important.
you could bring it up, to be perfectly frank, most of them, if you talk about rent and, you know, a multiplier or a cap rate or something like that, they're going to be like, what the hell are you talking about?
I've actually had them try to apply that, saying that when you're getting so much rent, you need to pay more. But my main point is, Jay was a crappy landlord and he's owed $18,000 in rent, so I buy it for 100 versus 150. The value's still 150. I'm just,
Yes.
if there's any argument there I can make to them, that basically he had to get out of this problem because he was too stupid not to.
Mm-hmm. I mean, if you're, it's not going to get you that far.
Okay.
Yes, ma'am.
All right, first of all, can you use the mic because there's a lot of noise over here. I don't know if they're cleaning it up.
I'll try. Hopefully
Thank you.
you're welcome. I'm sorry, it was like crackling before, so.
And then secondly, Jay mentioned for Detroit, the assessor review. So what's the date of the assessor review? And then do we have to file an assessor review?
In the city of Detroit, you have to file the assessor review by February 22nd.
Okay.
I believe this year is the first time I've seen it where it says that you don't actually have
Yeah,
to finish
and-
the assessor review to do the board review. Last year, they said, yes, you had to.
Yeah, and all years, to my knowledge, until this year, in Detroit, there was an extra step, and a couple other cities have it too. The city of Wyoming out on the west side, for example, had it. You can go to the assessor's office, or you go online and get a form. If you look, there's 3 full pages, and there's an explanation on, you can send it via email, you can go down there, you can put it in the mail, you can fax it to them, whatever.
Yeah, I had a question. Have you had luck where the assessment person pretty much took care of whatever you needed and you have to go to the board of review, or you still have to go to the board?
It's almost the assessor's review in my experience. I've done over 200 appeals, either my own properties or other people's properties, and of the 200, I want to say 3 had relief via the letter. You just give them a letter saying, I think it's overassessed because of this reason, and they're almost always just denied unless you've got a really solid defense right in the beginning. They're generally going to deny it. They want you to go to that board of review for some reason. But if you do truly have a good reason, it was saying that it's a 3-bedroom when it's a 2-bedroom, or you don't have a garage anymore when it used to, or something like that, go talk to the appraiser or the assessor down there and talk to them first. Sometimes they don't like you going to the board of review if they've made a mistake or they miscalculated somehow. So if you go to there, you're generally going to get relief if you go there first. But generally going to have to go to the board of review. The assessor isn't going to do much. The assessor review isn't going to do much.
Follow-up question, Jay. Did you represent your clients in final tax appeal?
Yes, I'm not an attorney.
No, I understand, but I'm saying as a property manager, as an agent.
Yes. There is a form that you fill out. It started to say, I'm not an attorney, so I can't represent them as an attorney, but there's a form. I can't remember the exact, they're essentially assigning their interest to you to be able to represent them. And as long as you get that signed and send that in to them, then you can represent them.
Yeah, and there are forms like that, and different communities require different types of that form. But in most instances, like Jay said, a property manager or some dude who's good at doing tax appeals, you can send out to do it. You just got to give them the proper authorization.
Question regarding Ward of March. So if I purchased my property in February of 2023, am I able to use the inspection report as a good source to summarize it, make it brief, and use that?
You can use it, but you just have to recognize that it's 2 years out of date at this point. And you can say, look, nothing has changed. It still looks just the way it did here. You can use it. There's no limitation on it except the practical limitation that it's a couple years old.
Yeah, I'm not going to use that exact report. I'm just going to summarize it in my own words, and then use it.
I see. Yeah, absolutely. Use it. It's a source of information for you. Yeah.
And you can always go back to the appraiser that did the appraisal for you and tell them, listen, I want to do a tax appraisal. They charge you sometimes less than your original appraisal would be because they only have to pull up a few comps and do it as of a certain date. They might do it cheap for you if you're going to go that route. So one question, how much do you charge specifically starting out for, like, say, the board of review, which I know for personal property or for, these type of homes, you generally don't want to represent them, but how much would you charge for that, and how much do you charge if you have to go all the way to the tribunal?
So, generally speaking, the way I handle property tax appeals is on some kind of contingency. It's usually it's a third of the savings for the first 2 years of the appeal because I mostly handle commercial stuff, and it takes longer to get that stuff done. You file it in May, you get your scheduling order, and by the time any action really happens, you're already into the following year. So I usually charge a third the first 2 years of whatever I can save for you. And, sometimes I spend a lot of time and make like $6 an hour, and sometimes I'm able to get a resolution and a big savings, and I do well, and overall it all kind of balances out. So that's how I do it. People do it different ways. My experience is that most people who do it on some kind of contingency or fixed fee. It's generally not productive to do it on an hourly basis because you never know how much time you're going to spend, and you never know what kind of results you're going to get.
That 2 years of whatever the saving of a third,
Yeah, so generally filing fees are the property owner's responsibility. Filing fees depend, in the tax tribunal, filing fees depend on how much is in dispute. And they top out at $600 for one property, although, for example, I had a client that appealed a subdivision that went belly up in Genesee County, and his filing fee was almost $2,000 just because you file the first one and it's a couple $100, but then you file the next 120, and it's, $25 or $50 a piece, and it doesn't take long for it to add up.
So the fee was a third of what we say per year, or just for 1 year? Or?
For the first 2 years.
So if you plan on selling this property, don't do it.
Yeah, Jay's right, it's not worth it. It's not worth it.
Yeah. Only if you're going to keep the property for long term.
Sir?
If I inherit commercial property in an LLC, is there an uncapping?
Yes. So if you inherited someone's membership interest,
Not like my parents.
yeah, the only instance in which that would not be an uncapping is if it were your parents' residence and then you moved in and lived there, or your son or somebody else moved in and lived there and you weren't charging them any rent.
Let's say if I have a successful appeal, do I have to re-appeal the system on an annual basis?
If you get the relief that you want the first year, why would you need to appeal? It shouldn't go up any more than the 3 to 5%.
And if I fail, am I able to reappeal next year?
I've done it many times.
You can appeal all the way up to, I believe, the Michigan Court of Appeals, I think.
Well, I mean,
only if there's a problem with.
Yeah, you can spend as much time as you want to. But most often, you get a decision from the tax tribunal, and the tax tribunal has a lot of discretion to decide what a property's value is. If the tribunal says, we think this thing is worth X, you then have an appeal of right to the Michigan Court of Appeals, but the chances of the Michigan Court of Appeals looking at it and saying, no, it's not worth X, it's worth Y, I can't really even describe how remote that would be. If you're taking something to the Michigan Court of Appeals, you're taking it because there's a problem in the way the tribunal has applied the law,
Legality.
rather than the way the tribunal analyzed the value of the property.
My understanding is that 95% of all tax appeals are settled out of court or whatever, that they, you go to the tribunal or go to the city afterwards and say, listen, we're about to go to the tax tribunal. All I'm asking for is this, and you can negotiate back and forth before going to it. That's one lawyer told me that statistic. I don't know the statistics, but I think it's a fair generalization that the overwhelming majority of tax appeals end up with agreement rather than a trial. You have to file, once you get past the board of review, you have to file an appeal. The assessor can't just change the assessment. They have to use the process that's in place, and the process is going to the tax tribunal. But you file your appeal in the tribunal, and then you have what's called a stipulation, and you submit the stipulation, and the tribunal enters a judgment saying the parties have agreed that the value is X, so the value is X, and that's the end of the case. Do you believe that the best evidence at a board of review or going up to the tax tribunal is an appraisal?
Generally, yes. Generally, yes.
Okay.
It's the exceptional case that it's not, like the one I described earlier. I was surprised at how successful that guy's testimony was, but I'm not eager to try that again. I want to go there with an appraisal. In most instances, depending on what kind of property you're talking about, you want to have an MAI appraisal, which means it's a really well-credentialed appraiser. For people like me, I like to say it stands for made as instructed. But it's a membership that appraisers have in the Appraisal Institute. That's what MAI stands for. Those are the people that the tribunal is going to look at as being the most credible.
And you can bring the appraiser with you to those. And I understand that the few that I've seen that they brought an appraiser, the appraiser doesn't actually talk about necessarily what the values are per se on their appraisal. They look at how the city screwed up their numbers and my numbers are better because of this. They're almost arguing that point, or at least the ones I've seen.
It really, you know, every hearing in the tribunal sort of has its own little life, you know, and they all unfold differently. As the taxpayer, as the petitioner, as you'd be, you have the burden of proof to demonstrate what the value is. So if you're there and you have an appraiser with you, you want to have that person say, here's why this is worth whatever my conclusion is. It's because there are sale comparables. It's because of the rents this thing generates. It's because of the cap rates for this kind of property in the market. You have to carry your burden. You have to put in enough evidence for the tribunal to look at it and say, these guys did what they needed to do to get a reduction. Because if you go there, there's a real sense in which the city or township can show up and do nothing. And if you as the petitioner don't do what you need to do, they sort of win just by your failure.
What would you say is the best way to prepare for a board of review, and or is there something that you can do when you purchase a property besides taking the pictures, etc.?
So, when you purchase, it depends on when your purchase is, but I would say the best way to prepare for board of review are the things we talked about, Jay. It's have your ducks in a row. You know, when you get there, know what you want to say to them, have information that's easy for them to understand and digest and to come to an agreement with you.
Do you generally pull the property cards for each one?
Always.
So if you don't know how to do that, every property has I think that's the actual name everybody uses, a property card. Right?
Record card, property card.
You can send an email to assessors at Detroit and tell them what your parcel address is and the address, and they will send you essentially all their information on it. It's like, you know, a disclosure essentially to tell you what they're looking at. You know, it has a picture on it, the room size and everything, and look it over to make sure that you believe that everything is correct. If something's wrong, that's the perfect time to do it, is in an appeal. What are the most common mistakes that property owners make when appealing for?
I would say, I mean, it's sort of non-specific, but the most common mistake is being unprepared, getting there and just saying, I think it's too high. Well, why do you think that? Well, because I do. You know, that doesn't get you anywhere. But it's relying on, you know, like you mentioned, Jay, relying on your purchase price. You made a good deal on your property, and that's great. And you know, congratulations to you if you did. That doesn't mean that the property is worth what you paid for it if you know you got a good deal on it. So over-reliance on a purchase price is one of the biggest mistakes I see all the time. Or over-reliance on, you know, if you have a multifamily property, if you had something atypical happen and you ended up with, you know, vacancy that isn't really representative of the property. Let's say, you know, property is evaluated at the end of the year.